I want to start by being really clear. I'm not an attorney. I'm a father who had to learn the hard way how to navigate a system that often treats your rights as a parent like they're just privileges. I had to figure out how to be heard, how to stay included, and honestly, how to protect my place in my own children's lives when it felt like every door was being shut in my face.
And that right there is the single most important thing I learned. Your rights don't just vanish because someone decides to ignore them. So if you're a parent and you feel like you're being silenced by schools, by doctors, by therapists, if you feel like you're being pushed out of the picture without a single court order saying you should be, then this explainer is for you. This is your roadmap to being heard.
So let's dive right in with the first major hurdle, and I call it fighting the silent wall. You know what I'm talking about? It's that incredibly frustrating experience of being completely ignored when all you're trying to do is be an active, involved parent. You call, you email, and you get crickets. It's like talking to a brick wall.
This quote from me just nails the problem. When professionals, teachers, doctors, counselors, start excluding you, it's almost always because they've bought into a one-sided story. At that point, they're not talking to you anymore, they're talking about you. They're making a plan to handle the difficult parent instead of just including you in your own child's life.
So where do you start? Right here. Your foundation is the law itself. You have to get this in your head before you do anything else. Here in Kansas, the law is crystal clear. Unless a judge has looked at the evidence and issued a specific order taking away your rights, you are a full rights parent. Period. This is not a privilege they can decide to give you. It's your legal right, and it's the starting point for every single conversation you have.
Okay, so you're probably thinking, well, if I have these legal rights, why does this keep happening? It's a totally fair question. And the answer is, it's usually not personal. It's a systemic failure. We need to look at the machinery behind this silence to really understand it.
Look at this number. It's just staggering. According to the Kansas Department for Children and Families' own data, 96.3% of all child abuse or neglect reports end up being unsubstantiated. Think about that for a second. The huge majority of calls lead to absolutely nothing. But every single call still triggers a response, and it trains professionals to react to the number of reports, not whether they're actually true.
And this right here, this is the engine of the whole problem. The law creates this incredibly powerful one-way street. If a mandated reporter, a teacher, a doctor, files a report and they're wrong, absolutely nothing happens. They have total legal immunity. But if they don't report and they turn out to be wrong, they could face criminal charges and lose their license. So what choice are they going to make every single time? They're going to report. It's all about their own protection. And this environment leads to a tactic I call report stacking. See, it's not one person filing 10 reports. It's 10 different people. A teacher, then a school nurse, then a counselor, each filing one report. They don't see the big picture, but the pile of reports creates this cloud of concern. And that makes schools and clinics really, really cautious. So they start restricting your access, even though there isn't a single court order telling them to. So what do? How do you fight this? Well, I can tell you how you don't fight it. Not by arguing. Not by getting emotional. That's exactly what they expect, and frankly, it just feeds the story that you're difficult. You win by being methodical, professional, and honestly, a little boring.
This is so important. I was told this directly by DCF counsel. They do not treat a bunch of unsubstantiated reports as a pattern of harassment. So if they won't track it, guess what? You have to. You beat the stereotype by creating a clean, professional, and undeniable record of facts. You let their own decisions and their silence tell the story for you.
And this is your engine, your toolkit. These 3 simple questions, and you always ask them in writing. Notice, they are not emotional. They're not accusatory. They are simple, professional questions that force the other person to justify why they're excluding you. Their answers, or as you'll often find, their silence, that becomes your evidence. This is how you box them in, ethically and legally.
Okay, so let's build on that method and get really practical. We're going to walk through a step-by-step playbook for when a private provider, a therapist, a clinic, a doctor, is just flat out ignoring you. And remember, the goal here isn't aggression. It's structured, documented escalation.
This timeline lays out a calm, reasonable process. You give the provider every single chance to do the right thing. You send your polite, initial email asking to be included, and you wait a full 7 days. If you get silence, then and only then do you move to the next step. By ignoring you, they're the ones choosing to escalate this, not you.
So after those 7 days of silence, you send this notice.
This is their final, professional opportunity to fix the problem on their own before you have to file a formal complaint. It's not a threat, it's a statement of fact and a final chance for them to correct their own mistake. If they still ignore you, the next logical step is a licensing complaint. But here's the thing about a licensing complaint. Its main purpose isn't to get someone in trouble. It's to create an official record that you have tried everything else. Judges want to see that you were reasonable. So you present a clean timeline of facts. No emotion, no story. Just dates, what you asked for, and how they responded. You let the record speak for itself.
All right, let's talk about another really powerful tool, the medical record. In court and with other agencies, what's written in a medical chart is often treated as the absolute gospel truth. So it is crucial that you know how to get your hands on it and, if you need to, correct it using federal law.
Now here is something that almost nobody knows. There are two very different types of access reports you can get. An accounting of disclosures only shows you if records were sent outside the clinic. You could get that report back, see that it's blank and think everything's fine, when in reality, dozens of people inside that clinic have been in that file. The internal access log, that's the one that shows you the whole story. So what if you get those records and you find things that are just flat out wrong? Like notes that say you refused care when you didn't, or claims of legal restrictions that don't even exist. Well, federal law, HIPAA, gives you a mandatory process to challenge it. The provider is legally required to respond to you in writing, and even if they deny your request, you can file what's called a statement of disagreement, which becomes a permanent part of the file, making sure your side of the story is always there.
Using a formal written request like this is so important. That legal language isn't just for show. It starts a 60-day clock that the provider is legally obligated to follow. It makes it impossible for them to just silently ignore you. It forces them to give you a written decision.
And this brings us right back to the central theme of this whole thing. Documentation closes doors that conversation just can't. This entire process is designed to create a clear, undeniable record. See, conversations can be misremembered, intentions can be twisted, but a clean, documented paper trail of your requests and their refusals, that is undeniable. It either forces them to comply or builds the exact case you need for a judge to make them comply.
Look, this isn't about picking a fight. It's about demanding clarity. Your goal has always been simple: inclusion in your child's life. And a methodical, documented, professional approach is the most powerful way I know to get there. You don't have to be loud to be heard. You just have to be persistent, and you have to be right on the facts. This process, it works. It's time to make it work for you.